Thank you very much. Good afternoon, everyone. Welcome to this examination preparation session for candidates who are writing the Conveyancing and Notary exams that are set for 11, 12, and 18 September 2024. Registration for these exams has closed and no late applications can be accepted. Please make sure that you all have your confirmation of registration letter or email from the provincial office. If you have not received this confirmation by now, you must reach out and contact your provincial office to ensure that you are registered for these upcoming exams. The registration letter or email will contain the exam venue, the times for the exams, your exam number, and all other information that you need to know. Allow me to start with introductions. My name is Melissa Murray, and I am the Senior Manager for Education and Training based at the LPC National Office. With me in the session are some officials and colleagues from the LPC National Office and provincial offices. And I'd also like to introduce our facilitators for this session, Ms. Christine Spears and Mr. Skalk van der Merwe, who are going to assist us based on their expertise and their experience with conveyancing and notary, and give you all the information that you need in order to ensure your success in the upcoming exams. We will take questions. If you have any, you're welcome to write them in the Q&A box. It's not an interactive session, so you won't be able to unmute yourself and speak. But if you do put questions in the Q&A box, we will be able to address them as we go. I'm now going to hand over to Ms. Christine Spears, who's going to start off with the session on conveyancing. Thank you, Christine. Over to you.
Thank you, Melissa. Good afternoon to all the conveyancing candidates. I just want to emphasize that the purpose of this session is to give you some background and to provide you with some detail as to what is expected of you in the conveyancing exams. Before I launch into the specifics, I would like you all to just take a moment and pause with me. I want you to take a deep breath and visualize where you find yourself in your own career path. I want you to be mindful of the fact that you, as a student of law, have already shown that you are capable of success. The degree that you hold and which provided you with the opportunity to sit for these examinations is evidence of this fact. I now want you to look at your career as if you are in the process of building your dream home. And yes, the pun is intended. This is conveyancing after all. I want you to see your degree as representative of the foundation of the building itself. By sitting for these exams, you are adding to the building. You are adding the top structure to the foundation. Focus on how you are now building the walls and how you are creating the different rooms. Move along the hallways. Now see the conveyancing exams as placing the roof on your house and the drafting paper in particular as all that finer detail of finalizing your dream home. You require an occupancy certificate to enable you to move into the house in order to live in it. See your admission certificate as a conveyancer as the parallel to this occupancy certificate. You need this before you may reside in this home. The quality of your experience living in this home will be determined by the planning, the effort, the skill, the expertise you put into building it. If the structure you build is not up to scratch and it is not maintained, you will sooner rather than later start seeing your home collapse around you. This is just the same as the conveyancing exams. By not studying the material and being able to address all the aspects involved in conveyancing, you will not be able to obtain a pass and get admitted. You need to remember that the learning never stops. You have to ensure that you remain competent in the field. It is essential that once you are admitted, that you maintain the process of continuing to stay abreast with developments and changes in the conveyancing field. These exams are specialized based on actual practice. As such, the expectation is that you have to present drafting skills which are in compliance with the practice and procedures of the deeds registries. You should note that the examiners are patently aware of the fact that you are writing these exams under stressful conditions and with time constraints. Please don't forget, All your examiners have had to go through this themselves, and this is taken into account when the marking of the scripts are done. Please ensure that the notes that you are using to study from, as well as the precedents you are working from, are correct and up to date. If you are studying material and are intending to attend any classes, please only use accredited and established courses so that you know that the learning you are doing is based on the correct material. If you find it better and easier to study in a group, set up such a group. The material is much easier to digest and understand if you do so with other people exploring the material with you. There is a golden rule by which examiners mark scripts, and this is: will the presented document or deed pass the scrutiny of 3 tiers of examination in the deeds registry? If what you have drafted does, you will most certainly pass the exam. If what you have drafted doesn't, then you cannot expect to pass by attaining the required 50% pass mark allocated to that question. It is then also rather unlikely that you will be able to obtain even an opportunity to sit for an oral exam if this problem presents itself throughout your exam script. Please make sure that your numeracy and accountancy skills are up to scratch. Presenting wrong accounts for sellers and purchasers will mean that you will not get valuable marks to help you obtain a pass mark for these kind of questions. You will be best served to remind yourself of the importance of avoiding trust account shortfalls. A conveyancer remains ultimately responsible for the accounts and the actions performed by him or his staff. The most complaints, if not all, which the LPC have to investigate against conveyancers relate to the handling of the finances in conveyancing transfers. In performing any conveyancing mandate, you will be required to put together some sort of account. It is for this reason that this forms an essential part of what you will be tested on to be admitted as a conveyancer. The best advice I can offer you all is when you are preparing to write the drafting paper, that you practice with loads of examples of deeds, applications, accounts, agreements, powers of attorney, and so forth. As I have mentioned earlier, these are practical exams. Please don't let this statement be lost upon you. You will be tested on practical scenarios. If you have never seen the inside of the deeds registry, how it functions, what a lodgement jacket looks like, and what it contains, a lot of the practical scenarios may be very difficult for you to understand and address. My advice to you on this issue is to be proactive about this. Speak to practicing conveyancers and try and arrange that you can shadow them or their staff members when they attend to their daily deeds registry run. When you have seen these processes in action, it helps with understanding them better. This ultimately makes the studying process easier, and it also prepares you for what you will be required to do as a practicing conveyancer. I would now like to take you through the exam process itself. Conveyancing examination paper 1 is for 100 marks. You have 2 hours to complete the paper. This paper tests conveyancing theory, but may also include some questions relating to the drafting of parts of documents or the shorter types of documents. Conveyancing examination paper part 2 is for 200 marks. You have 4 hours to complete the paper. The paper predominantly requires you to draft conveyancing deeds and documents. Most of these questions are phased as practical scenarios, and you have to ensure that you answer these questions taking into account the facts as they are presented in the question. If you break it down, you effectively have 1 minute per mark available. Use your time wisely. You have the benefit of not having to write both these papers on the same day, and you also have the benefit of not having to write both papers in one examination session. This concession was introduced a few years ago, and it is for your benefit. Please make sure that you read a question in order to understand what you are being asked to answer. Please do not read simply to respond. This is exactly the same as in practice. See these questions as clients sitting in a consultation with you. You have to listen to understand what the mandate is that they require you to perform for them. If, by way of example, the question states that the owner of the property giving transfer of the property is John Doe, then you need to refer to the transferor as John Doe by citing his full name, full identity number, and his marital status. If the facts in the question state that he is married in community of property, then you have to reflect him as such. And even if the facts of the question do not provide you with the spouse's full names and identity number, you will have to make up those facts to have a complete description of the transferor. Any facts you make up must not be contrary to or in conflict with the instruction, and it must be in line with the applicable legislation. If you are asked to draft a document, do not draft 2, 3, 4 documents. Not only would you be wasting that precious time, but your examiners in this instance will only mark what you have presented as the first document. All the other documents which you have spent time on drafting after that first document will be disregarded. By drafting more than one document in such an instance, it clearly shines a spotlight on the fact that you have not read the question properly and that you are not following instructions. If a question states that you have to list in your answer, do not write page-long essays. This will result in you running out of time to get through all the questions. If a question instructs you to list, for instance, 5 documents, and you list more than 5 documents, only the first 5 documents will be marked and the rest will be ignored. Depending on the nature of the question and the instructions, you may also end up being penalized for doing so. For both examinations, you are afforded 15 minutes to read the paper before you are permitted to start writing. Use this time to read to understand what you are required to present as your answers. If you embark on a journey down the wrong path, the examiners will not follow and give you marks for effort. If your answer is completely wrong, for example, if you have drafted a wrong document, you will not be awarded any marks. If the document you've drafted is liable to be rejected by the examiners in the deeds registry, that document will be marked out of a maximum of 50% of that question's allocated marks. Please make sure that you read the list of instructions on the front cover of your question paper. These are not negotiable instructions. Failure to adhere to these instructions will be to your detriment. Write only in black pen and write neatly. If you write in pencil, your script will not be marked. In effect, you are required to follow the deeds practice even if you are now sitting and writing an exam paper. When you invent registration numbers for an entity, and these are completely wrong, you will be penalized. For example, if you use the wrong suffix for a trust and quote incorrect referencing to indicate that your entity is a closed corporation, and I say again, these are practical competency exams, and you are therefore expected to know what these numbers and what that suffix is supposed to look like. Your answer script is a book. You write only on the right side of the book on the pages with the lines. You may use the left side, that is now the back of the pages with the lines, to make notes for yourself. This will not be considered by the examiner when allocating marks. It is merely available to you should you need to use it. You have loads of line pages in your book. You may even ask for a further book if you do run out of pages. You will have more than enough space to answer the questions adequately. You do not have to answer the questions in chronological order. You have to clearly indicate which question it is that you are answering. Absolutely no typics. You were advised of this when you wrote your competency-based examinations as well. For the conveyancing examination, you absolutely will not have an excuse to use it. Do not even bring it with you to the exam venue. If you make a mistake, draw a line through the wrong part. Just try to do this as neatly as possible so it doesn't detract from what you are presenting as your answer. And then do not forget your calculator, please. I've mentioned earlier that you will be tested on accounts. If you are asked to draw final accounts for sellers and purchasers, you will have to show apportionment calculations. You cannot do this without the assistance of a calculator, and your cell phone or smartwatch may not double up as your calculator. Conveyancing drafting is not an exact science. Everyone has a different drafting style. Your examiners are all senior conveyancers with many years of experience, and as such they are patently aware of the fact that there are different drafting styles. They all allow for this when marking. Where you are asked to draft a deed which has a prescribed form, you have to adhere to the prescribed form. If you use the wrong form, you will not be given any marks for your answer. Wrong form, no marks. In summary, I would like you to remember these three key words: know, understand, apply. The know requires you to be familiar with the applicable legislation and common law principles which apply to the broad conveyancing field. Therefore, a study of the applicable legislation and a working knowledge of the forms prescribed by those pieces of legislation are essential. The understand requires you to ask yourself the question: what are the facts presented in the question? Or what is the practical situation which I'm required to resolve? Therefore, you need to read and identify what the question requires you to draft, taking into account the mark allocation to the specific question. The apply requires you to show your examiners that you are able to apply your knowledge of the legislation and the forms by drafting the correct deed or document. I now want to just mention a few things about the syllabus. Could we please just get the syllabus on the screen? You have been provided with the new syllabus at the beginning of August. If for any reason you have not received this, please follow up with the LPC. The syllabus was updated for this examination sitting, so please make sure you use this specific syllabus. Just waiting for that to come on screen.
Can you see it now, Christine?
No, it's not opened yet. The attachment's still closed. There we go. It's now on the screen. As I've mentioned, this has been sent out to you. Please just have a look at that heading and you will note that it refers specifically to the examinations of the 11th and 18th of September 2024. Now you will note that in that introduction, it mentions that you need to be familiar with conference resolutions and chief registrar circulars up until 2024. On your screen, you'll see on your syllabus it says 2023. When we get lower down, there's going to be one exception, which I will take you through when we get there. But just for clarity purposes, we don't have conference resolutions yet for 2024, but we do have some chief registrar circulars that have been issued in 2024. But I will address that when we get to it. Now, the reason that you have to know these conference resolutions and chief registrar circulars is because they are absolutely essential to your day-to-day practice as a conveyancer. And I'll give you some examples just so that you can understand what it is I'm referring to. Under Registrar's Conference Resolution 3 of 1940, it was determined that co-owners need not consent to the amendment of the name of an owner when a Section 41B application is presented for registration. Another example is Chief Registrar Circular 6 of 2002, which deals with the provisions relative to the Subdivision of Agricultural Land Act of 1970. This remains very crucial to the conveyancing practice. And even though both these examples I've given you are old, they are very, very relevant. Even if you do not memorize the reference number to these resolutions and circulars, I know it is a lot. The content of these kind of resolutions and circulars impact on your day-to-day practice as a conveyancer. And it is for that reason that this is included in your material. Now, just scrolling down, you will see that there is a list of the pieces of legislation that is relevant to these examination. We will get to that now. Just stop there where it says requirements. The very first reference there relates to the primary legislation for conveyancers, that being the Deeds Registries Act and the Sectional Titles Act. This is not negotiable. You cannot practice as a conveyancer without being acquainted in full with these two acts and their regulations. Although you are not required to memorize per se the prescribed forms contained in the regulations, you still need to know which forms to use when presented with specific scenarios. Even though you are provided with the handouts of these acts, you will not have time to page through searching for answers. Scrolling down, you will see that the relevance are all self-explanatory. I just want to go one step back, sorry, just on page 2 of the syllabus. Reference is included to the Acts and Ordinances 3.3, and in particular, reference is made to the Margalit Supreme Court of Appeal judgment. I have sent you that as well, Cabello. If you could possibly open that piece of legislation, that court decision for me on the screen. We'll revert back to the syllabus shortly.
Is this what you're looking for?
No, the case that we sent you.
The case itself.
Sorry, the case itself.
Okay, let me see if I can find it. Just give me 1 second. I'm not finding it. I'm just having the syllabus this side. We can share it perhaps at a later stage.
Okay, no, that's fine. I just wanted the candidates to actually have a look at the fly note relevant to the case itself, because that fly note in itself explains why this case is so crucial as part of the study material. It highlights what is considered to be negligence and what kind of thing will result in a conveyancer being held liable for damages. It is really, really important for study purposes. We can move on, so don't worry about sharing that. It is referred to in the syllabus. The whole citation is available in the syllabus, so that's where you will find it. You can just revert back to the syllabus, Kabelo.
The syllabus should be back on.
No, we're still seeing the email screen. Thank you. If we can just scroll down to 3.3, because that is where we left off. So you will see the full citation of the case there. Please make sure that you obtain a copy of this case and study it in full. Then going down that list, the sections pertinent to conveyancing in the other pieces of legislation mentioned have to be studied as is outlined. Then moving on to page 3 of the syllabus, we get to K. This is the reference to the Companies Act. It is incredibly comprehensive. Aspect K. What you need to be made aware of here is that there are specific references to sections of the old Companies Act as well as to the new Companies Act, as they are applicable in a conveyancing practice. And it is here where I just need to point you to that very, very last reference under K, which refers you to Chief Registrar Circular 2 of 2024. Now, up until this year, we have basically been working off a 2013 Chief Registrar Circular, the reference number 28 of 2013. Please note that there were amendments made to that circular and it has been replaced in full, and that the Companies Act is now dealt with comprehensively in Chief Registrar Circular 2 of 2024. Please make sure that you obtain this specific circular to study these provisions from. And then scrolling down, just further references to the relevant acts as they apply. We see the Consumer Protection Act there in the relevant sections, and on page 4, Donations Tax, Income Tax, Insolvency Act, the whole of the Interstate Succession Act, the provisions of the Land Survey Act. You can read and study through all of that as it is outlined. It is quite specific. And then on page 5, it starts off with the Spaluma provisions. You see the entire of the Subdivision of Agricultural Land Act there. You see the pertinent sections under MM quoted for the Value Added Tax Act, very popular for your theory questions in particular. And then I just want us to stop at QQ. Now, these references relate to the Chief Master's directives, as is listed there. As mentioned in the syllabus, you can access Chief Master's directives quite easily from the Master of the High Court's website. Please, I need to just emphasize that you should not disregard these specific directives. They are incredibly important, specifically from a drafting point of view. And then you will note that at the end of the syllabus, it just refers to the following acts and indicates that 10% of marks may be given in any given paper relevant to these things. So you can just scroll down on this page. You'll see, as mentioned, and then under the general, once again, the mention of the broader-based study material that forms the outline of the course material that you study. And I think that takes us to the end of the syllabus. And this wraps up our exam session for the September conveyancing examination. I want to just take this opportunity to say to you all that with dedication and spending time on practicing your drafting skills on loads of examples, and by making sure that you are working and studying from the correct material, there's no reason for you not to be able to pass these examinations and pass it well. All the best and good luck. Thank you, Melissa.
Thank you. Thank you very much for that, Christine. And thank you for taking the candidates through the syllabus and what it is that they need to focus on and how they can be successful in these exams. There's just 2 questions that have popped up in the chat. If I can just put them to you. The first question is, do we need to refer to the specific sections or regulations in the exam?
You will have to read the question to see exactly what it is that is being tested. Generally, the very specific sections will become very pertinent when you draft documents. For example, if you are asked to present a change of name document, you will have to know that in the heading of that document, you will have to disclose the fact that it's an application under section 93(1) of the Deeds Registries Act. So that is why it's important that you know which section relates to what. But as I've mentioned, we are understanding of the fact when the marking process takes place that you are under time constraints and that it is a very difficult situation to try and remember all these things. So where it is pertinent to the answer that it has to be reflected, the answer is yes, but your answers are also considered holistically before a mark is allocated to it, if that answers your question.
Thank you. Thank you very much. There's another question. Is it correct that you do not need to add signatures on the documents that you draft?
Yes, that is not necessary, but what you must please just remember is when you draft, specifically in your drafting paper, if you are going to be asked to draft a draft deed of transfer, and it is the Form H to the Sectional Titles Act, for example, you are required to write out the preparation clause. So the preparation clause has to have that little statement, prepared by me, with a space, conveyancer, conveyancer's name, LPCM number. If we see that prep clause, we know that you knew that that is what you needed to do. Also, things like leaving the blank spaces when you draft deeds. Draft your deeds in your answer sheet as if it is an actual deed that you're going to present. But as far as the signatures are concerned, we need to just see that you show us that there will be witnesses to the document where that's pertinent or where the applicant will have to sign. But an actual signature itself is not necessary.
Thank you, Christine. If you don't mind, there's just another question that's popped up here. A candidate has asked if you could maybe just give some information on how the accounts are marked. Do they only get marks if the calculation is absolutely correct? Do they get marks for correct descriptions? If you could maybe just give candidates a little bit of information about how we go about assessing their papers.
Obviously, if you have apportionments to show in your calculations, if you show your method of calculation, you may get some marks for showing the way you've calculated. Obviously, if the amounts are wrong and your accounts are wrong, you may get some marks, but you will most definitely battle to pass with more than 50%. It is because if the question that is posed to you give you specific amounts, it gives you specific dates in order to apply the apportionment on, then there is an expectation that you will actually calculate these things in a proper manner. So that is how that is viewed. So you may make up some marks for showing the actual entries, but you will not be able to get full marks if your figures are completely wrong.
And then I think there's just one last question, if I can just ask. When drafting, do we draft according to our deeds office, especially when a question mentions, for example, Polokwane? Can we still describe the property as we would in Pretoria?
Yes, there is allowance for this. There are some provinces that use the administrative districts in a different manner to other deeds registries. The examiners are examiners from generally all the provinces, so this is taken into account. What you do just need to watch out for is if you are asked to draft a document and the question scenario tells you that it will be presented for registration in the Cape Town Deeds Registry, please do not then draft, for example, a power of attorney where you authorize the conveyancer to appear before the Registrar of Deeds in Polokwane. That would be considered a mistake. So read your questions so that you're clear on the scenario, but with regard to the descriptions, the practices of the province in which you are practicing will be taken into account for your benefit.
Thank you. And then I think the last question that's just popped up before we move over to Notarial is, can you explain which information you can make up in the exam when not all details are given?
In the example that I've given when I took you through the discussion, I mentioned if they say to you John Doe is married in community of property, but they didn't give you John Doe's wife's name, then you can give her any name. What we are referring to is, please don't write, for example, identity number and just draw a line. Put in a 13-digit identity number so that it's very clearly identified as a transferor. If the question said, John Doe is married in community of property to Jane Doe, then please don't tell me on your answer that her name is Kirsten Doe. You are then not following the instructions and using the information presented to you in the example.
Thank you very, very much, Christine. I really appreciate that. I think you've covered all the questions that have popped up here. I can't see any more that have come through. So if I can just thank you for that session and thank you for taking the candidates through the syllabus and what's required of them, and also for giving them that general information as well, in that they can prepare for the exams. I'm now going to hand over to Mr. Skalk van der Merwe, who's going to take us through the notary section. Mr. van der Merwe, if you can just unmute yourself and go ahead, please.
Thank you, Melissa. Afternoon, everybody. Firstly, thank you, Christine, for that well presented introduction. I must say, I hope all you aspiring notaries didn't switch off when you heard it was conveyancing first, because the principles that were outlined and how you need to deal with the paper and the information and all that kind of thing, I can only echo on that. It is extremely important. I'm not going to repeat all of it because it all applies whether you write a conveyancing or notarial. If I can start by saying that what I've seen over the years from candidates and looking at the results of the exams that we mark, there's definitely the examination for notarial is totally underestimated. You must understand that to become a notary means that you become a specialist in a field. And it's the only legal office held by a South African lawyer that is recognized almost universally without further questions. It's an important part of your legal makeup, and its integrity and stature should be protected. And that's in the first instance by keeping the standards for admission to practice as a notary on a level in keeping with the status of the profession and the knowledge and skills expected from a notary. Of importance is the weight that our courts not only bestow on a notary, but also demand from the office, as voiced in a number of court cases. Now, I'm going to give you 10 points to ponder and consider. The first one is, do not underestimate either the office of a notary nor the skills required to practice as a notary. If you keep that in mind, you will focus on your studies, and you will focus on the paper and make sure. And please don't write this exam and say, well, I'll take a chance. I passed my conveyancing. I can just as well try. Don't try. Study hard and get it done. 2, most notarial deeds require registration in the Deeds Office. So knowledge of the Deeds Registries Act and its regulations are essential. Drafting the deed without proper regard to the vesting and property descriptions, for instance, will do you no good. We find that specifically in oral examinations, the candidates would tell us, but you can't ask me that question, that's a conveyancing issue. Not true. Conveyancing also, or the Deeds Registry Act for that matter, is also needed when it comes to notarial deeds. Number 3, read the question. Make sure you understand what is required of you before you answer. Don't just go off on a tangent. Questions are mostly drafted with the basic information that your layman client would provide, without knowing or caring what specific document would be required. So, for instance, the client would come to you and say to you that he needs to consolidate his 2 properties. You need to know that when it's possible and when a notarial tie agreement should rather be drafted. He wouldn't know. And the question that will be posed to you in the paper is a practical question, as the client would present you with a problem. So read the question, and then with your knowledge and your studies, come up with the correct answer. So the question, therefore, as much tests your knowledge of what would be required as the actual drafting. Number 4, and this was also voiced by Christine, practice your drafting skills. There are little prescribed forms when it comes to notarial documents. Although the Deeds Office will not interfere with your document other than with reference to the Act and regulations or requirements, the document should be unambiguous and capable of easy interpretation. Have your principal, partner, or study mate look at your drafting. Don't just scan through documents. For instance, an antenuptial contract. Sit down and try and write that out without reference to any example, so that you can know that you know what to do and that you understand what you're doing. Next one, number 5. Tell the story, but come to a conclusion. We find many candidates writing, whereas this, and whereas that, and whereas the other. And then suddenly there's a servitude or a whatever, but there's no now, therefore, in reaching the conclusion. Your whereases are nothing worth, or worth nothing without a now, therefore. It's the heart of your document. It's the causa of what you're doing. And it should explain the impact and intent of the document. Number 6, this was also mentioned by Christine. Correctly identify the document in its heading. This shows that you understand what is required to be done and helps the examiner to follow your logic to the conclusion or object of your document. You actually get marks for the heading. Number 7, remember that the law attaches a higher degree of understanding by the parties to a notarial document than an underhand document. This is because it's required of the notary to explain the document and its import to the signatories, and it is assumed that the notary has indeed performed this function. Some questions are therefore bound to be asked to test not only your drafting skills, but also your understanding of certain legal principles. For instance, the difference between personal rights and personal servitudes. Few documents will be rejected by the deeds office because of the content. Your objection will one day come when the matter serves before a court. So be alive to that. Number 8. When you do your exam, you're only required to get to 50% to pass. Mark between 40 and 49% allows you the privilege of an oral examination. The oral is not a re-examination. In other words, if you pass the oral, it does not necessarily mean that you pass the exam. It's an opportunity to show that you indeed have a clear understanding and rational thought process, and to prove to the examiners that your failure to have achieved 50% in the written paper was an obscurum intervallum, and that had the pressure of writing an exam or the lack of time to think not have numbed your senses, you would have passed the first time. Do revisit the questions and answers you gave so that you are able to prove that you know where you went wrong. Do not ignore the written paper in your preparations, although, of course, questions are not confined to the paper. Number 9. Remember that a notary keeps a protocol in which, inter alia, all documents providing proof of authority of signatories to notarial documents are filed. You should therefore also have knowledge of what documents are required to prove such authority, obviously with reference to the founding document of the specific party or underlying applicable statute, for instance, the Companies Act, and so forth. Draft such resolutions. You may well be asked to do so. Number 10. The office of a notary requires a sound knowledge of the law in general and a specialized knowledge of matters notarial. You all have received the syllabus. I'm not going to go through that. It's very much the same as with conveyancing. It's the same issues that come to the table. Do not ignore this legislation in your preparation. It is important that you understand what you're doing. On my side, that's it, apart from good luck.
Thank you very, very much for that, Mr. van der Merwe. If there's any questions, can we see them in the Q&A? I haven't seen any questions so far. If you haven't yet received the syllabus that was emailed out, please just send me a mail, and I've been responding and emailing it to candidates already. So if you haven't received for either conveyancing or notary, you can just send me a mail and I'll send that to you quickly. There was one question that popped up for conveyancing. Christine, I don't know if you mind answering. The candidates are just asking, do we need to leave 4 centimeters when drafting in the exams, as per Regulation 22? So there's just that query. And I think that's the only one, the only last one. Christine, are you able to answer that for us? If you can just unmute yourself. Okay, I think we don't have the connection there. But no, when you're writing an exam, you don't need to leave your 4 centimeters because then you would run out of space on a page. But you do need to set it out exactly as it would be per the regulations. Let's have a look. The session is being recorded. If you go to YouTube and you go to the Legal Practice Council page on YouTube, you'll see all the exam preparation workshops. We always put them there, as well as any other information or sessions that we have for candidates. So yes, everything has been recorded. You can go along and listen to it again. It should be made available this afternoon or tomorrow morning. I'm seeing some emails coming through for the syllabus. That's great. I'm happy to share that with you. I'm just going to take a moment to see if there's any other questions that have come through. If you were too shy to ask a question today, you're more than welcome to also email me. My email address I have put into the chat. It's melissa.m@lpc.org.za. Alternatively, you can send it to info@lpc.org.za for my attention, and the emails will be sent to me directly. Mr. van der Merwe, there's a question here regarding a Commissioner of Oaths. The question is, to save time, can we just say to be commissioned before a Commissioner of Oaths, or do they have to set out the full story?
I think if as long as we can see that the candidate knows that it has to be commissioned, unless, of course, once again, the question requires you to give the full wording. But if it's an add-on to the question, it should be fine.
Perfect, thank you. And then one last question that popped up. In the notary exam, do they have to sign at the end as the notary and initial all the pages?
No, that's not necessary. As long as you do end your document, conclude the document with provision for the signatures and provision for signature by the notary, so that we know that you know who should sign the document. So, for instance, when it comes to notarial bonds, we want to see that you know who should sign the notarial bond, and which documents are unilateral documents and which documents are to be signed by both parties, and where the notary should sign. So indicate indeed that this is the space for the notary, this is the space for the whoever, but you don't need to sign it physically.
Thank you very much. And then just two last questions that popped up. One here says, is it important to consecutively number pages where a deed comprises of more than one page?
I can't see that you'll lose marks if you don't number the page, as long as it follows. Remember what was said by Christine earlier, is that you don't need to answer questions in the sequence that they asked on your paper. But also remember that the poor marker needs to understand. So you need, if it's necessary to show where you are with a certain document, please number it. Otherwise, make sure that you don't mix up your answers. It becomes very difficult when we have an answer that says to be continued on page 11 or whatever, and then there's another answer in between. So deal with your questions, even though you don't have to deal with them in the same sequence, but deal with every question, complete the answer of that question before you move to the next question.
Thank you very much. Mr. van der Merwe, just one more question. Do they need to know the Chief Registrar's circulars for the notary exam?
Yes, indeed. In as much as they affect description of parties, description of property, etc., etc. So, yes, do look at that as well. We don't expect you to off the bat remember the circular number, but the import of it is important.
Thank you very, very much for those answers. That's all I have. I haven't got any other questions that have popped up here. And I've gone through and I've addressed all the questions in the chat box. So I think at this stage, we are moving towards the end of our session. I just want to remind candidates of a few things before we close. Remember, the morning of the exam, you must have that registration letter or email that you received from the provincial office that shows that you are registered for the exam. So please print a copy of that. Also, you need to have your original ID. We cannot accept a certified copy or a photocopy or a picture on your phone. That won't be acceptable to allow you into the exam. So please, in order to get access into the exam room, your original ID and your registration letter. Nobody will be able to help you that morning if you don't have those documents and your original ID. You won't be given access to the exam room. As we've mentioned previously, remember to only write in black ink. Please do not use pencil or any other colors. Some of you like to use, write your headings in different colors. I know you want it to look pretty, but we cannot mark anything that's written in any other color than black ink. And this is because when we mark the papers, our markers use red. On remark, they use green. When it's moderated, they use purple, so that you can see all the different examiners who have looked at your paper. So if you've also used different colors, we can't tell what you've written and what an examiner may have written on your page. So please, you need to write in black ink only. Write only on one side of the page, the lined side. So we will only mark that side of the page. And as Christine mentioned earlier, leave your Tipp-Ex at home or your correction tape. You cannot use Tipp-Ex in this exam, in conveyancing or notary exam. It will not be marked, and it will actually be an irregularity, and we might have to investigate after the exam session. So please just leave it at home. If you make a mistake, draw a neat line through it and start the question again. Also, don't tear pages out of your answer book that's given to you. If you make a mistake, put a line through it. Please don't tear any pages out. At this stage, I just want to thank Mr. van der Merwe and Ms. Spears, who was here with us today in the session, who gave you all information regarding the upcoming conveyancing and notary exams. I trust this helps you with your preparation and also gives you a little bit more confidence entering into these exams. If you haven't received the syllabus, please email me. Also, if you have any questions following the workshop today, you are welcome to email me and we'll assist where we can. So I just want to wish you all good luck for your preparation and good luck for the exams. I know these are challenging specialist exams. Some of you are writing for the first time. Others have been with us more than once. But I really want to wish you all the best. With hard work and preparation, you will see the results that you want. So thank you to everybody for joining us for the session today. Thank you to our presenters. Like I said, it will be posted onto YouTube if you want to listen to the session again. And if there's anything, you're welcome to reach out to us afterwards. But thank you, everyone, and the session is adjourned. Thank you.